BWI Ltd and 7 others against the Attorney General of the Turks and Caicos Islands.
Yes, Mr. Missy.
Thank you, my Lord. My Lady, my Lords. If I might, the way I propose to present the case for the developers is in the following order. First, I would briefly outline the positions of the parties in the courts below and the way those positions were treated by those courts. Secondly, I would give a brief outline of the party's position before the board today on the issue that the board has to decide. Thirdly, I would make very brief submissions on the principles of interpretation and in particular on the internal context of the relevant contractual provisions. Fourthly, I would make somewhat more detailed submissions on the proper interpretation of clauses 4.13 and 4.14 to demonstrate that the construction advanced by the developers is to be preferred over that advanced by TCIG.
Thank you. You appreciate we have read the parties' written cases and the judgments of the court below, so we're reasonably familiar with the way in which the case has developed.
Yes.
So you can skim quite quickly over those first two sections of your...
Yes. I intend to do that, my Lord. Then, fifthly, I propose to make submissions as to the effect of part performance. The developers having spent nearly $700,000 on the island improvements on the date, as at the date when the Crown Land Ordinance came into force, relying on the case of Sweats and Harper, which is at page 843 in the electronic bundle. And then finally, I will address the submissions made on behalf of TCIG that the 2013 agreement extinguished any binding obligations which TCIG was under the 2008 agreement. Returning firstly to the positions of the parties, the developer's primary case in the courts below, or the primary declaration that was sought, was a declaration that there was a binding agreement under the 2008 agreement as amended by the 2013 agreement for a lease of the downtown restoration parcels, and that agreement was not affected by the Crown Land Ordinance, which was not of retrospective effect. It was only if the court was to held that the CLO was of retrospective effect that the developers claimed constitutional relief. TCIG's primary defense was that the 2008 agreement was rescinded and replaced by the 2013 agreement, so that any obligations under the 2008 agreement was extinguished. And it is important in my submission to see what the judge, the Chief Justice at first instance, said about that in paragraph 18 of a judgment, which is at page 298 of the appeal record. He said, TCIG's primary defense to the application is...
Did you say 288?
298, my Lord.
I misheard you. Thank you. Yes, got it.
TCIG's primary defense to the application is that the 2008 development agreement is of no effect, and that there has been an innovation of the agreement by the 2013 development agreement, and that the developer's right and the TCIG's obligations are governed by the later agreement. And this important question she posed to herself. The question must first be resolved, this question must first be resolved before the court can move to consider whether TCIG is right to assert that its agreement to execute a lease for the downtown restoration parcels in favor of development is subject to and limited by the provisions of the Crown Land Ordinance. Now, the Chief Justice held that the 2013 agreement rescinded and replaced the 2008 agreement and failed to grant the declaration because she held that paragraph 56 of her judgment that TCIG was not seeking to apply the Crown Land Ordinance retrospectively. That is at page 303 of the appeal record, paragraph 56 of her judgment. In the Court of Appeal, the only issue was whether the 2013 agreement rescinded the 2008 agreement. And this can be seen from paragraph 1 of the Court of Appeal judgment at page 315 of the appeal record. At paragraph 1, Mr. Appeal Justice Ederle said, "The appeal seeks to determine whether or not the trial judge was right to hold that a development agreement dated 18th of April 2008 entered into between the appellants and the respondent was rescinded by a subsequent agreement entered into between them on the 18th of August 2013. So that was the issue that the Court of Appeal had to determine. Now, the Court of Appeal overturned the decision of the Chief Justice that there was a rescission and not a variation, and also granted the declaration that the CLO was not of retrospective effect. That declaration is in the order of in the judgment in the order of the Court of Appeal. Without the issue being raised in the Court of Appeal and without hearing any arguments, the Court of Appeal decided or concluded that the expenditure of $2 million on the island improvements was a precondition. That is in paragraph 66 of the Court of Appeal's judgment.
Page?
At page 331. Now, in making that decision, or in coming to that conclusion, the Court of Appeal was purporting to rely or purporting to affirm a decision to that effect by the Chief Justice. But the Chief Justice never made any specific finding that the expenditure of $2 million was a precondition to TCIG's obligation to grant the lease. There's another aspect of the Court of Appeal's judgment which I need to refer your lordship to, and it is in paragraph 5 of that judgment, where the Court of Appeal made a statement. And I use the word statement rather than a finding, rather than a legal finding. At paragraph 5, the 6th line, so this is at page 315. Paragraph 5, the 5th line, the Court of Appeal made this statement, talking about the downtown restoration parcels. It said, these parcels were to be embodied in a lease to the developers at a peppercorn rent per annum if and immediately after they had invested $2 million in the island improvements as defined in the agreement. Now, TCIG has latched on to that statement in support of their case, of its case. Of there being an offer of a unilateral contract by TCIG. But that statement does not comport with the language of Clause 4:14.4. And that language is in, so the language of Clause 4:14.4 is in the appeal record at page 18. Clause 4:14 says, in consideration of the island improvements, the Crown shall grant the developer within 15 days of delivery by the developer to the Crown of reasonable satisfactory proof of the developer's expenditure of not less than $2 million in the island improvements, the downtown restoration parcel. So that is what the clause actually said. And so there is a divergence between what the statement that the Court of Appeal makes in relation to that paragraph and the actual language of that clause. So not only did the Court of Appeal make that statement, but it gave no explanation as to why that statement ought to be interpreted to be what the parties intended by the language of Clause 4.14.4. So it must be either the natural language of Clause 4.14, or it must be that is what the party must have intended by the language of Clause 4.14.4. And the Court of Appeal made no analysis as to how it came to make that statement. And so we would say in due course that that statement has no independent value in terms of the decision which the board has to make. So that's all I want to say about the positions of the parties in the courts below and the response of the courts below. Turning now to the position of the parties before the board. The developer's case is that Clause 4.14.4, which I've just read, created a binding bilateral provision, or was a bilateral provision, which created binding obligations on the developers to carry out the island improvements and to spend not less than $2 million of their own monies on it in return for TCIG's obligation to grant the lease. TCIG contends that there was no bilateral agreement, but an offer by TCIG of a unilateral contract under which TCIG would grant the developer the lease if the developers spend $2 million on the island improvements. So the case is that the developers were under no obligation to, and they could incur that expenditure, but was under no obligation to do so.
Fine. Why does it matter whether they were under an obligation to do so?
Well, that is the way they put their case.
So far as you're concerned, if you've done it, then they were obliged to enter into the lease. The real issue is whether that obligation survived, or whether it was replaced by a new obligation in the 2013 agreement.
Yes, well, my lord, I would submit that is the crux of it, and That is, I see it, the matter that was before the Court of Appeal, which is the Court of Appeal decided in favor of the developers.
Well, they may have done, but we've got to decide what the true analysis of the clause is.
Indeed.
I mean, it was argued, as I understand it, before the judge on the basis of the whole agreement being novated, but it doesn't seem to me at the moment that we need to decide that question. What matters is whether the particular obligation to enter into the lease was replaced by a new obligation.
Yes, my lord.
Even if other obligations may not have been replaced. We haven't looked at the whole agreement.
Yes. Well, my lord, I'm happy to address that. I'm happy to address that now, or I was going to address the submissions made by the Crown on the actual interpretation of Clause 413(3). But if your lordship thinks that is not...
Mr. Missing, you take your course. We seem, by almost common consent, to have stumbled very quickly on what, at least provisionally, we think may be the main issue in the case. And if you want to go straight to that, by all means do. But if you want to develop your submissions about the difference between the courts below on Clause 4.14.4, by all means do.
Yes, well,
I have to say that subject to correction from anyone else on the board, Lord Leggett's question of why that was critical was one which I think I would have shared, and he and you both answered it by saying what really matters is what the effect on 2008 was of the 2013 agreement.
Yes, my lord.
Bearing in mind that the Act had come along in the meantime.
Bearing
in mind that the Act had come along in the meantime.
Yes, my lord.
Can I just be clear? You are accepting, are you, that it makes no difference whether it's a bilateral or unilateral contract analysis?
Well, my lord, if there was no variation of these particular provisions, Clause 14 and 414, if those clauses, sorry, let me put it this way, if Clause 4.14.4 was rescinded and not varied, as opposed to the entirety of the agreement, then it does matter whether or not the CLO, it does matter whether or not it's, it would have been affected by the passage of the CLO. That's where I can put it. So just to make it clear, so I would accept that if the CLO,
if the clause was replaced, then you would have accepted it was affected. But let's suppose it had not been replaced. Let's suppose this clause had just stayed in effect all the time, and then you had spent $2 million. Then it couldn't have been said that the CRO was had affected that right, because this contract was made before the CRO came into effect, and so you'd be entitled to the lease.
Yes, indeed.
And you would say that even if the last few cents of the $2 million had been paid after the Act came into force?
Yes, my lord, because I would say there's been part performance.
Well, anyway, you would say that the Act wouldn't have upset Clause 4.14.4 if it had remained unamended, even if the $2 million hadn't been paid at the time the Act came into force.
Yes, my lord, yes.
Providing it later was.
Yes.
Yes.
That's what I would say, yes.
Yeah.
But the developers would, on any version, have had to incur the $2 million expenditure in order for the obligation to transfer the lease to become applicable.
Well, it would be in order for performance of the obligation, but not for the existence of the obligation.
Yeah.
And why does that make a difference?
Well, because if the obligation existed prior to the CLO, the CLO would not affect the existence of that obligation. So all that TCIG had to do would be was performing an obligation which existed prior to the CLO.
But how do they perform that obligation? You say if the construction of the 2008 agreement was that there is an obligation, that obligation precedes the CLO and therefore is unaffected by the CLO.
That is my case.
And I just want to make sure that I understand the second limb of your case. In 2013, the obligation, and I'm not going to say rescission or variation, the obligation on any assumption was changed. The words are different. I'm not saying any more than that. So your case is it that an obligation arose in 2008 which can't be affected by an order which is not retrospective, and that obligation survives and can be fulfilled under the terms of the 2013 agreement?
2013, yes, my lord.
Right, so then you can just say, I've given you notice, please vacate downtown, hey presto.
Well, my lord, the reason why I say it's because the answer to your ladyship question is that you have to look at the source of the obligation. The source of the obligation is the 2008 agreement. The content of the obligation may have changed. The consideration may have altered, but the source of the obligation is and always was the 2008 agreement. And
that's the key point, as I see it.
Yes.
I could see that if the new agreement 2013 had said we amend clause 4.14.4 so that we reduce the expenditure from $2 million to $500,000, then you could say, well, it's a continuation of the same obligation, but it's been amended. But that isn't what happened. As far as I can see, they scrubbed 4.14.4 and wrote out wrote out a new set of provisions which bore some similarity but also significant differences from the previous agreement, and that looks to me like a new obligation.
Well, my lord, what I would say about that is that the Court of Appeal, I understand that your lordship would wish to visit the matter afresh. But what I would say about that is that there has been no appeal from the decision of the Court of Appeal, which and this very issue was raised in the Court of Appeal as part of the so-called rescission. And so that issue was decided against TCIG because
Well, I'm not saying it's necessarily the case that the whole agreement, the 2008 agreement, was rescinded and novated. But what seems to be critical is whether, as part of whether the relevant part of the 2013 agreement simply altered a continuing obligation or replaced it with a different obligation.
Yes. Well, my lord, I would say it was a continuing obligation, and the obligation here was to grant the lease at a rent, at a peppercorn rent. That was the obligation.
Well, to grant. So, by here, you mean in 2008?
Yes.
It was to grant a 99-year lease.
Well, a 99-year lease at a peppercorn rent.
Yes.
Right. And that obligation to grant the lease at a peppercorn rent was not altered.
Well, is not the current obligation under 2013 to grant a 999?
Well, yes, my lord, I see. Yes.
So another 900 years has been added on.
Yes.
But that may not, in valuation terms, make an awful lot of difference, but it is different.
Yes. Well, my lord,
I'm sorry. The premise too is different, is it not? Because as I understand it, what is said against you is that the 2008 agreement did not contain any obligation to grant the lease unless the developer spent $2 million.
Well, I would not say, what I would say is the 2008 agreement required expenditure as a condition or the grant of the, not a condition precedent to the existence of the obligation, but as a condition for TCIG's performance of its obligation to grant the lease. And that was the consideration, or that was part of the consideration. And that part of the consideration was altered. So the fact that the consideration was altered does not, in my submission, mean that it is a new obligation or that it's a new agreement. And I will come to...
Can I just test that with an example? Suppose that before the Act was passed, the Crown entered into an agreement to grant a long lease of the property for a premium of, let's say, $10 million.
Yes.
And after the Act was passed, they varied that by promising to grant exactly the same lease, let's forget the extra 900 years for the moment, but at a premium of, say, $10,000. Would you say that reduction of the price entirely escaped the Act because they still promised to do the same thing? I'm just giving an extreme example to see where we're going and where, if there is one, where the dividing line might come.
Yes. Well, my Lord, I would say this, is that you have to look at it not only in terms of what TCIG was giving up, but also in terms of what TCIG was getting.
Yeah, no, but just help me with my example.
Yes. Well, my Lord, I can see that that is a drastic variation in terms. And so, obviously, the more drastic the variation in the term, the less likely that one can say it was a variation. I can see that.
But if you just ask, well, was the implied provision against retrospectivity in the Act one which would enable the Crown to jump out of an obligation to sell land at market value and replace it with an obligation to sell land for, relatively speaking, peanuts, will one say that the Act didn't apply to that?
Well, my Lord, I can see that that would be something that was radically different.
Yes.
Yes, and so as a matter of interpretation, one could say that
interpretation of the Act or interpretation of the agreement.
No, interpretation of the agreement.
Right.
You can say that it is so radically different that it amounts to a new agreement. But what I would say is looking at this as a whole, TCIG was also under an obligation to spend $2 million on the island improvements. And under the 2013 agreement, it was no longer under that obligation to spend the $2 million. So in terms of value that TCIG was getting for the lease, if you look at the consideration in the round, I would say that there has not been such a drastic alteration in the consideration.
So what is the consideration that you're now saying that TCIG is getting? I mean, you use this phrase that the 2008 agreement was the source of the obligation, as if it was being contrasted with the content of the obligation or something of that kind. I mean, what exactly is the agreement as you now see it? Did do the developers have to spend anything?
Well, under the 2008 agreement, they already spent $700, so they didn't have to spend any more than $700.
They weren't required to spend $2 million under the 2008 agreement.
Well, my Lord, that's where I differ with TCIG's case.
You submit they were required to spend.
They were required, yes. That they were required. If you look at clause 413 and 414.
So what is the content of their obligation, as you argue? You say, well, what's gone before is neither here nor there. They could have spent nothing, and still this obligation to grant the lease would apply, would it?
No, my Lord. What I say is they were under an obligation to carry out the island improvement and spend $2 million on it. Under the 2018 agreement, that was varied so that they no longer had to spend any more money in order to earn the lease.
Well, certainly for my part, it would help me if you would just, in a few propositions, spell out what in your submission the relevant aspects of the 2008 obligation were, and correspondingly to what extent they have changed under the 2013 arrangement?
Yes, my lord. Under the 2018 agreement, the developers had to carry out the island improvements. They had to spend $2 million of their own money on it. TCIG had to also contribute $2 million.
It was a dollar-for-dollar obligation.
Yes, yes.
Yes.
As at the date of the 2013 agreement, and as at the date of the CLO, the developers had spent $700,000. TCIG had contributed nothing. And under the 2013 agreement, TCIG was relieved of their obligation to spend at all. And the developers were relieved of their obligation to spend any more than they already had. So that was specific in relation to the lease. But there were other provisions in the agreement, other monetary provisions in the agreement, which was a benefit, other changes in the monetary provisions of the agreement, which was a benefit to TCIG. But the ones I just mentioned are those that are specific in relation to the lease.
So TCIG are not bound ultimately on your analysis to do anything?
Well, no, because their obligation was...
To get the lease, I mean?
Well, they're not in the obligation to spend any money.
So what are they, if anything, bound
well, they're obliged now to grant the lease on the developers giving notice that they intend to proceed.
Yeah.
So the consideration is what?
Well, the consideration for the lease is, the consideration arose under the 2008 agreement, i.e. the carrying out of the island improvements at an expense of not less than $2 million. But that consideration was reduced from $2 million in the case of the developers down to $700,000.
But that consideration is gone. That's past consideration, isn't it?
So
what is the fresh consideration on your...
No, my lord, it's not past consideration, because it was $2 million they had to spend. They already spent part of that consideration. They were simply relieved of spending more than what they had already spent. It's not I would not say it was past consideration. It was a consideration which was reduced under the 2013 agreement.
But what's TCIG getting now, from their perspective, under the agreement as you now construe it?
Yeah, it no longer has the obligation to spend $2 million, to contribute $2 million.
Right.
If you put those two together, $2 million's been replaced by 0.7, plus arguably letting the Crown off another 0.7. So on any view, 2 million's gone down to 1.6. No, 1.4.
Yes.
Even if you treat being let off an obligation to spend something as a relevant addition to the consideration.
Yes.
Yeah.
So in my submission, that amounts to a reduction in the consideration. It is not the creation of a new agreement, and I obviously rely on the case of the Australian case, which deals with the question of the source of the obligation, which is in the authorities bundle. Sorry, it's in tab, but it's in. It's the case of. Can you help me with that?
Certainly, but I appreciate you're going to show us this authority, and I don't want to divert you from your task, but from your course, but certainly at some point I would welcome your assistance as to the support for your proposition that the developers were required to spend $2 million.
Okay, that's more.
But you can come back to that. I just want to put a marker down because.
Yes.
But yes, you're going to show us the authority now.
Yes, I was going to take your lordship to the Australian case of Commission of Taxation against Sarah Lee, where.
And can you give us the reference for that?
Sorry, my lord, it's page 472 of the authorities bundle.
Yeah.
Where there the court obviously made the distinction, and I appreciate that. This case helps me only if your lordship, or only if the board decides that this was a variation, because that is the whole premise of the case, is that if there's been a variation of an agreement, the source of the agreement remains the original agreement, and so that is. The passages.
And the particular proposition you say you derive from this case is?
Well, that the proposition is that if there is an agreement, I derive two propositions from it. First, if there are two agreements, the second of which varies the first.
Yes.
The source of the obligations remains under the first. That's the first proposition. And the second proposition is that it does not matter that there was a change in the consideration.
Well, I can see that if you've got a clause like on page 479 at the top of the page,
Yes.
Which says that the amendment, the agreement shall be deemed an amendment and except as provided the old agreement remains in full force and effect. But on the face of it, the agreement we've got looks like they scrubbed out the obligation, all the obligations in clause 4, and replaced them with a new set of terms. That's just how it looks.
Yes.
So I don't know how you get to the opposite conclusion.
Well,
I think you're going to come to that in due course, aren't you, Mr. Missick? But I think you prefaced your invocation of this case by saying this only helps you if we're with you on the concept of it being a variation rather than a replacement.
indeed, my lord.
But even if it is only a variation, and therefore leaves the obligation under the original agreement in force, it did so in that case for capital gains tax purposes, didn't it?
Yes, that was, yes.
It's nothing to do with whether a piece of legislation that comes along later, which is not assumed to be retrospective, is or isn't triggered by the variation of the obligation.
Well, my lord, what I would say, yes, what I would say about that is that if the change in legislation, the change in legislation itself, I would submit, does not affect the original obligation, and the variation of that obligation is not one which the new legislation was intended
to deal with.
To do it. It wasn't intended to restrict the powers.
Can you just take us to the key passage in the High Court's, in the reasoning of the majority in the High Court?
You mean the Court of Appeal or High Court?
In the Australian case?
Australia.
Oh, sorry, the
I thought it was High Court of Australia.
Yes, sir.
High Court of Australia.
Yeah.
Sorry, yeah.
Yes, my lord. It's at page 483.
483. Thank you.
Yes, 483.
Yeah. It's all about when the asset was disposed of, is it, in this case?
Yes, my lord. And so we would say, in this case, the question is when is the obligation to dispose?
Yes.
To dispose of the, by way of the lease arose. We say it arose under 2008 agreement. And the change in the terms, 2013 did not alter that agreement. So it's, if I could just, it's a paragraph.
Well, it's section 160U3 of their
Yes.
Capital Gains Tax Act, isn't it, on page 484 in
484,
paragraph
yes.
37.
It's, well, there are two different judgments in which this appears. The first appears in the judgment of at 488, paragraph 49.
Okay.
Is one of the passages.
Yeah.
Where there are two or more contracts which affects the rights and obligations of the parties to a disposal of assets.
Yeah.
The identification of the contract under which the assets were disposed of for the purposes of applying Section 160U of the Act requires a judgment as to whether the contract is properly to be seen as the source of the obligation to effect the disposal. In the present case, that contract is the purchase and sale agreement of the 31st of May, that being the first contract. And then going backwards,
Yeah.
at paragraph 42, it says the words under a contract in section 106TU direct attention to the source of the obligation which was performed by the transfer of assets which constituted the relevant disposal. From May 31st until completion of the 30th of August 1901, there was a contractual obligation upon the respondent to dispose of his assets to Roach or an entity of the kind referred to in clause 12.3 for the purchase of the sale of the agreement. The content of that obligation did not change. The price was varied, as were certain other terms and conditions of the sale, but the agreement of May 31st was the source of the obligation, which the respondent discharged by performance on August.
Yeah.
So that is the passage that I relied on. And then,
But I think you accept, don't you, that there comes a point where, for example, the price might change so much that it even though the source of the obligation remained in the earlier agreement, the Act would still be effective to prevent
yes, my lord,
a radical price change.
yes, my lord. And again, I accept that.
Yeah.
But again, what I say, and I know your lordship has pointed this out to me before, is that the change in the price, in this case being the obligation of the developers not to spend any more money, was the very issue that was before the Court of Appeal, and the courts below. And so it is my submission that this issue was decided by the Court of Appeal, the issue of whether the change in the obligation from $2 million to $700,000. That was the issue that was before the Court of Appeal. And the Court of Appeal decided that as part of its overall
analysis
of the variation. Its variation, its analysis of the variation of that it was a variation, included a conclusion that that variation also applied to the expenditure of the $2 million on the Downtown Restoration of parcels, because that was the issue before the Court of Appeal, and that was in terms of the variation. It was only that issue that was before the Court of Appeal, and there has been no appeal against that finding.
Well, there doesn't need to be, does there? Because the respondent is arguing that the result arrived at by the Court of Appeal should be upheld, and one of the grounds on which it says that is so, well, admittedly it's its second argument, but it's there in its case, page 443, is that the source of the obligation was the 2013 agreement, which is exactly the point we're raising.
Well, my lord,
provided you put it in your case as a respondent, I believe you don't need in the Privy Council to serve a respondent's notice.
well, my lord, there was no respondent notice.
No, they doesn't need to be. Is the
Right. Well, my lord,
The point is there in their case, so you've had plenty of notice of it at
Well,
page 443.
yes, my lord, I have
It's not
noticed of it.
very lengthily dealt with, but it's in issue.
Yes, well, my lord, the way they put it is a different way. The way they put it is that the old obligation was extinguished because of clause 1.10 of the agreement. That is how they put it. If
Yes, sure. Yeah,
does your lordship see that?
I do.
Right, okay, so now it is my submission that clause 1.10 cannot be relied on to support TCIG's case. And I will come back to the question of the construction, but can I deal with that point now? And I will make these submissions in relation to that aspect of the argument. First, I would say that clause 1.10 is superfluous.
Sorry, I missed that. Clause 1.10 is...
It's superfluous because a contracting party cannot agree to do something which the law prevents it from doing. That applies to TCIG or anybody else. So it adds nothing. That's the first point, but not the most important point.
Can you just give me a page number for 1.10?
I see, my lord. 1.10 is page 8.
Thank you. Ready?
Page 8.
Oh, sorry. Well, that's 1.
Oh, sorry, yeah. Okay, I'm coming back to that. It is the wrong. That is in the 2008 agreement. That's one of the points that your lordship will see I will come to.
I think it's 133. Is that right?
So, my lord?
Is it 133?
133.
Yes.
Yes, 133. Yes. It says it is agreed that obligations of the government extend only so far as it may lawfully agree. So I made the first point on that. The second point I will make is this, is that clause 1.10 was not included in the 2008-2013 agreement in response to the Crown Land Ordinance. It is a standard clause found in development agreements to which TCIG is a party.
It was in the 2008 agreement.
It was in the 2008 agreement in exactly the same language.
And I think also in clause 1.10. But I may be wrong.
Well,
it doesn't matter. It was in the 2008.
It was in the 2008 agreement in exactly the same language. So, so clause 1.10 was not a variation, not even of the 2008 agreement. It was simply repeated in the 2013 agreement in exactly the same language. And so it follows in my submission that it applies only to obligations which would have been unlawful for TCIG to have entered into in 2008, because that is the source of that clause.
Well, even if the source of the clause was then the 2013 agreement, you could say it begs the question, because if it was a new obligation, well, then they couldn't lawfully enter into it. If it was just varying the old one, then they could.
Well, my lord, no, my lord, they didn't vary this obligation.
No, not this one, but in any event, as you say, that they couldn't lawfully enter into a new obligation, but they could lawfully vary the old one, couldn't they?
Yes, my lord. Yes.
So,
yes, and so the operative words here was lawfully agreed. That's why it must relate to the date of the agreement, i.e. being the 2008 agreement. This clause was not intended to foreshadow a change in law. They were talking about changes in obligations which were unlawful at the date of the 2008 agreement. So that is my second response to that. My third response is that, and it follows from that, is that it was not unlawful for TCIG to have entered into the 2008 agreement, and the point my lord just made about the variation. My next point is that it is inconceivable that that these sophisticated parties would have intended that the developers would give up an important right by the side wind of a standard clause in the 2013 agreement, which was repeated, which was taken from the 2008 agreement. My next point on this is that again, it is inconceivable that these sophisticated parties would have, and in particular the Attorney General, would have agreed to enter into an agreement in 2013 which they or she knew was unlawful. And there is nothing in the context, and I appreciate there was very little circumstances before the court as to the courts below as to the external context of the agreement, but there's nothing in the context or in the language of any of the provisions of the 2013 agreement which indicated that the parties felt or believed that the provisions that they made in the 2000 agreement were adversely affected by the by the Crown Land Ordinance.
Well, there was a clause that said that if anything in this agreement turns out to be unlawful, we'll negotiate around it.
Well, my lord, I'll come to that. That is in clause 1.5. I'll come to that momentarily.
Right.
But do you say, well, they should be taken to have been aware of the ordinance, that they can't have intended to enter into an agreement which the Crown would be unlawful for the Crown to perform, and therefore they must have intended this to operate as a variation of the old agreement and not as a new one?
Indeed, my lord, that is a submission that was made below, and a submission that was accepted by the court below. And then just before I move on to clause 1.5, there's one other point I would make about this, is that the submission is contradicted by clause 4.14.2 of the 2013 agreement, which is at page 142. It is drafted in rather convoluted terms, but it suggests that the obligation on TCIG would be immediate.
Yes.
Can I just follow through your proposition that the parties, or at least TCIG, could not objectively have intended something that they knew to be unlawful? I mean, might it be said, well, they may well have been aware of the position. The advantage for them is that they would then be in a position to pull out from this deal should and when they wanted to.
Well, my lord, that would suggest, and I would not want them to suggest that TCIG would be, that would suggest they would be acting in bad faith when they enter into an agreement that they knew to be unlawful with a view to coming out of it. That is not a proposition in my submission which ought to be attributed to TCIG. And while I'm on it, can I address the point, my lord, you made about clause 1.5?
Yes.
Clause 1.5 in the 2013 agreement, and I make 2 points about that.
Can we have a page again?
Oh, sorry, clause 1.5. It's at page. This is the 2013 agreement.
Yes.
1.5. Let's see.
132, I think.
Yes, bottom of 132.
132. Thank you, my lord. Yes. It says, in the event that one or more of the provisions contained herein shall be held for any reason to be illegal, invalid, or unenforceable, the party shall negotiate in good faith, and so forth. Well, the first point I make about that is also contained in the 2008 agreement, and it is simply a repetition of what the 2008 agreement said. But more significantly, and the second point I make about it is that clause 1.5 applies only where a provision, to use the word, was held to be unlawful. So it envisages a situation where, after the agreement was executed, a court of competent jurisdiction strikes down the provision as being unlawful. And so in my submission, it does not apply. It cannot be relied on. It is of no help.
Well, both the judge and the Court of Appeal have held it's unlawful, haven't they?
Well,
in different ways.
Yes, my lord, but the time to look at this is when it was on. We have to go back to the date of the agreement, the 2008 agreement, because this is, again, this is a clause which.
Oh, I see. You're saying there was no 2008 illegality.
No, my lord. No.
Right. Understood. Yeah.
So that deals with that. Can I now go back to the question that was posed earlier as to whether or not the developers were under an obligation to spend the $2 million? First of all, can I say I accept the propositions of law about the principles of interpretation set out in the TCIG's case, and the developers did not refer to those principles because the board is well familiar with them. The overriding principle is to balance textualism with contextualism. As I said before, in this case, there was little or no evidence before the courts below, and certainly none before the board, as to the external context in which the 2008 agreement was executed. However, there are a number of matters in the internal context which, in my submission, are relevant to the interpretation of clause 413 and 414. The first is although the agreement, 2008 agreement, was drafted with the help of professional legal advisors, it is clear that it suffers from a number of drafting infelicities, and that is a relevant matter to be taken into account. The second is that the carrying out of the island improvements was in the commercial interest of both parties. From TCIG's perspective, it would improve a deteriorating public asset, which would then be maintained by the developers at their own expense under clause 617 and 614 of the draft lease, which is at page 43. TCIG would earn tax revenues from the operations of these facilities. From the developer's perspective, they would have the benefit of the use of the improved asset as part of their business. Secondly, or thirdly, the cost of carrying out the improvements were to be shared equally between the developers and TCIG. Your Lordship has already seen that and is aware of that. The board is already aware of that. But it was the developers who had the obligation to carry it out. And this is accepted by TCIG at paragraph 60 and 68. So TCIG accepts that the developers were on an obligation to carry out the island improvements.
May I just see that, please?
Sorry, my Lord.
Could you just give me that reference, please?
Paragraph 60 and 68 of their written case.
But are the island improvements defined in a way which requires the developers to do them regardless of how much money is stumped up for the purpose?
Well, my Lord, I hope I will answer that question in the next few submissions.
Okay.
Yes. So the next point I was going to make is that the cost of the island improvements was uncertain. But the parties knew how much money they want to spend on it. They were not willing to spend more than $4 million. The next point to draw from the internal context is that the parties knew that this $4 million would be insufficient to carry out the whole of the improvements. And we say you are able to infer this from paragraphs 4.13.2 and 4.13.5, both on page 18. 4.13 says the developer shall, in consultation with the government, prepare an implementation plan setting out aspects of the island improvements to be carried out first, and in what order. So there was to be an order in which they were to be carried out, and which were to come first. And then in paragraph 4.13.5, the developer shall use commercially reasonable endeavors to ensure that as much of the island improvement as possible can be carried out within the total budget of $4 million. So we say that is an indication that they knew that the whole of the island improvements would not be able to be carried out within the budget of $4 million. And it's important to know here that the reasonable endeavors clause relates not to the expenditure, not reasonable endeavors to spend $2 million or to spend $4 million, but it relates to the as much of the island improvement as possible.
Where are you looking now?
Clause 4.13.5.
As such, the island improvements are defined in clause 1.1.19 on page 9.
Yes.
And that takes you to the island improvements exhibit.
Yes.
Which presumably contains some sort of specification of what they're meant to be.
Westmore, there were lots of specifications, and it was quite an elaborate. There was quite a lot of. You can't see it from the bundle, because yeah. But there were some specifications.
Is the exhibit not in the bundle?
The exhibit is here, but it's not readable.
Right.
Well, what do you say exactly the developer's obligation was?
Well, their obligation was to carry it out, and to spend at least $2 million of their own monies on it. And I will come back to.
Obviously, you're saying it wasn't to complete carry out all the island improvements, because you say that there wasn't enough money for that. So,
well, my Lord,
I don't think they promised to spend $2 million.
Well, my Lord,
they promised to spend a maximum of $2 million.
Well, my Lord, I'll come to that. Because that is the point. That is the point that the TCIG makes. That they focus on the word maximum, and I'll come to deal with it. Is whether maximum should be interpreted in that way.
But 4.13.7.
Yes.
4.13.7 says that in no event shall the expenditure obligations of the developer or the government exceed $2 million each.
Yes.
But that is expressly limited to the clause. As I understand, your submission is that it would cost more than that.
Yes.
But there was only an obligation under this clause, in terms of its parity and so forth, to spend $2 million each.
They had to spend $2 million each. That is my submission.
But isn't the 4.13.5 requires the developer to use commercially reasonable endeavours to ensure that as much of the island improvements as possible can be carried out within the total budget of $4 million. It sounds like they promised to get going on the content of this illegible exhibit.
Yes.
And to do it on a sort of cost per unit basis that ensured that as much of it as was in that exhibit that could be done within a budget of $4 million was done, with each side having the obligation to pay for it up to $2 million each, but with the developer being entitled to stop work at 4.13.6 if the government fell into arrears with its payments.
Yes, yes.
But an entitlement to stop rather presumes an obligation to do them.
Indeed,
That's your point, presumably.
Yes, my Lord. That is one of the points I made.
Yeah.
So that is it. Then the next point I make is that.
Perhaps, I'm sorry to interrupt, just
Yes,
before you do go on, I think one gets a little bit of an idea of the improvements we're looking at page 86, the bundle, where one has a table of contents for the island improvements exhibit.
Yes.
So at least there's a list there.
Yes.
of the kind of things, Airport Road, etc., historic district, downtown waterfront, various things.
Yes.
I'm sorry to have interrupted.
Yes, my lord, I'm thankful for that. So those are some of the things that the developers did that were included in the island improvements. Yes, I'm grateful. Then the next point I make about that is that in terms of the general internal context is that both parties had immediate binding obligations leading up to the carrying out of the island improvements and the grant of the lease. For example, you would see in clause 4.13.1 that the developers had an obligation to obtain planning permission.
Yes.
To the extent that it was necessary. And under clause 4.13.2, they were obliged to consult with TCIG in the preparation of an implementation plan. And we would say that TCIG was under an implied, if not an express, obligation to make itself available for consultation and to participate in the preparation of the implementation plan.
There must have come a time when the developer's obligation got suspended, because it's common ground, isn't it, that the developers spent nearly 0.7 million, and the respondent hasn't paid a penny.
No, but more, it's not clear from the document, but I'm not sure that the reason why the developers stopped was because of the suspension.
No, but if the developer hasn't paid 0.7 million, why isn't clause 4.13.6 triggered as a matter of entitlement? Regardless as to why the developer did suspend the work.
It is, Lord. Oh, yes, my Lord. All I'm saying is I am not sure that that was the reason for the stoppage. It's not been a part of the case, but it certainly would have been entitled to do so. Yes.
Yeah. You're not relying on their failure to match you dollar.
No, that has not been part of my case.
Yeah.
And I don't want to rely on something now that I didn't rely on before. But certainly they would be entitled to do that. But what I would say is that obviously there were negotiations going on since 2010, leading up to 2013, and obviously during that period, there was no work being undertaken. Then, in this, you would see that developers were required to make monthly reports to the government of the expenditure and work progress. That's under clause 4.13.4. And then TCIG was under an obligation to reimburse the developer 50% of those costs. And finally, TCIG was under an obligation to grant the developers a reduction of 5% of the import duties on all materials, and that would include the materials for the island improvements under the development order, which is at page 44. So we say, looking at, it is in that context that you have to examine whether or not, and how to interpret clause 4.13 and the provisions that TCIG rely on to say that the developers were under no obligation. And so what we would say before I turn to that is that this case does not fit neatly into the textbook example relied on by TCIG of A offering £500 to B if B walks to London. This is not that case. But now
it's not that case anyway, because even if you didn't have an obligation to spend $2 million, And I can't see at the moment how the government, on any view, hadn't promised, given a binding promise in 2008, that if and when you did spend $2 million, they'd transfer the lease. Yeah. There was consideration on any view.
Yes.
There were all sorts of obligations that were undertaken.
Yes, my lord. Yes.
Regardless of whether one of them was that you would spend $2 million.
Yes, indeed, my lord, yes. So can I focus on, can I just spend a few minutes on, just to respond to the points which my TCIG has raised about the question of obligation. And they obviously rely considerably on clause 4.13.3 and the use of the word maximum in that clause and in Schedule 2. And I would say that about this. First of all, as I said, the word maximum must be construed in the context, and in particular in the context where the parties knew that the $4 million was insufficient to carry out the whole of the improvements. So maximum, we say, must mean, the maximum of $4 million must mean that it is a fixed sum rather than a cap. And the purpose of the word maximum, insofar as it was necessary to use that term, was to make it clear that the parties were not obliged to spend more than that amount, although it would have been in the developer's interest for the developer to spend more. And looking at the clause closely, you would see that the obligation to spend $2 million is not itself expressed to be a maximum. Because clause 4.13.3 says, there's a total cost of $4 million, of which the developer shall contribute $2 million, and the government $2 million each. So the words "of which" is of the $4 million, each should contribute $2 million each.
And so, putting it in your own words, what was the obligation? What was the extent of the obligation on the developer under this clause?
To spend $2 million.
That's all. Not to carry out the work with its best endeavours to do it within $2 million. It's just to spend $2 million.
It had to carry out the works insofar as the $4 million, the total $4 million could do so, yeah. And to spend of that $2 million of its own monies.
But the obligation was in this sense conditional. It was conditional upon the respondent paying its share as you went along.
Yes, I would say it's conditional in the sense that the developer was not obliged to continue to perform.
Exactly. Yes, there was a right to suspend.
Yes.
Yeah. And not to cease altogether, but to suspend.
To suspend, my lord. And yes, because it says if and insofar as and as long as.
Yeah.
Right. So it's not a stoppage.
Yeah.
It's a suspension.
Yeah.
And if you remove the word maximum from clause 4.1.3, it wouldn't alter the meaning of that clause.
I think you mean 4.13.
Yes, my lord, yes.
Yeah.
It wouldn't alter the meaning of the clause.
Well, Mr. Missick, speaking for myself, I want to hear mainly from you on your submissions about what I think you and Lord Leggett agreed at the outset was the key question, namely whether the changes wrought by the 2013 agreement were such as to take the case out of that sort of continuing original obligation category to which the Act would not apply.
Yes. Well,
that seems to us to be the crux of it, and that's what we want to hear you about.
Well, my lord,
I say that now because you've only got another half an hour or so, slightly less.
Yes.
And we do want to give you all the time you need to make your submissions about that question.
Yes, my lord.
certainly for my part, I found this analysis of 4.13 very helpful.
Yes. And so, my Lord, I have partly addressed that question.
Yes.
I
I want
partly
to make sure
addressed,
you get all the time you need to address it in full.
I partly addressed that question, but to the extent that I can add to what I have already said, what I would say is this, is Clause 4 both Clause 4.14.4 in the 2013 agreement and in the 2008 agreement I can see that there is considerable difference in the wording of the two provisions because Clause 4.14 4 is now replaced by the obligation to serve notice on the government that the developer is ready to proceed to carry out the island improvements. But the terms of the lease that is to be given, that is, and the terms of the lease that is to be given are also changed in two respects. One, it's well, it is altered in the sense that it's 999 years and not 99 years. But other than that, the terms of the lease is the same. And we would say that a lease for 989 years and one for 99 years is not that much of a substantial difference to make it less, to make it a rescission and not a variation.
I think it was 49, wasn't it, under the 2008 agreement rather than 99?
It was 99, sorry. It's 99 under the 2008 agreement.
Well, I thought it was 49.
Sorry. Yes, my lord. Yes, my lady. You're absolutely right. 49 to 99 years. 999 years, yes. Yes, it is my... You're absolutely correct about that, yes.
I thought it said 99 in the Statement of Facts and Issues. Is that a mistake?
That must have been, yes.
Yes, it does say that.
Yes.
It's 49 on page 43.
But it is 49, yes. And...
Can you just help me on this?
yes.
In the 2013 agreement, I'm on page 141, there is a completely new 4.13 about the island improvements, which appears effectively just to leave it to the developer to decide how much of them to do. Looking at 4.13.1.
Yes.
With various best endeavours aspects to it. And some of it involves restoration of key historic buildings downtown.
Yes.
But then 4.14 is now about, well, actually it always was about downtown restoration. But what's the difference? Is the downtown restoration a subset of the island improvements?
Yes, my lord. That bedeviled me for a long time.
I mean, is it in another illegible exhibit?
It is another exhibit, yes. Yeah. And this is, again, an example of the infelicity in the drafting. So you will see that 413 deal with island improvements, but the obligations in relation to carrying those out appear under downtown restoration.
Yes.
I think that downtown restoration was road signs, certain buildings, and possibly something to do with the marina, whereas the improvements that we looked at, there was that list that I referred you to, which is at page 86. So I'm not entirely sure whether it is entirely a subset, one or the other, and I'm not sure that it is.
It is confusing, but I gleaned that the downtown restoration parcels would include both the island improvement as well as the downtown restoration, because they're all part of the same property. They're all within the same property. Is that correct? Yes, they're all within the boundaries of the lease which TCIG was to give the developers.
Right. Thank you. But what's troubling me, Mr. Missing, help me if you can, is this. You accepted in an interplay between us earlier on this morning that even if a later agreement is expressed in terms of variation rather than replacement of an earlier one, the variation may be so radical that for the purpose of deciding whether the non-retrospectivity exception in an act which would otherwise make full performance of the later agreement unlawful, it has to be treated as caught by the act, caught by the legislation. Yeah. And trying to find out what the principle of law is that enables one to identify variations that are radical in that sense and variations that aren't.
Yes. Well, my lord, the law or the principle of law is that all depends on the intention of the parties.
Can that be right? I mean,
yes, my lord. It is the so.
When what we're talking about is whether an exception to retrospectivity in a piece of primary legislation applies or not.
Well, my lord, the anterior question is whether or not there was a variation or a rescission. So until you've answered that question, so you have to answer that question first, and obviously the answer to that question will depend on whether or not the change in law applies. So the interior question is, was this a variation or was this a rescission?
But don't we then, in any event, let's assume one has decided that it's, either way, whether it's a variation or rescission, isn't there still the question whether on the correct interpretation of the statute should be construed as applying to one or both?
Yes, no, yes, no, that is the case, because the point of the statute is this: well, there are two elements to that. First of all, there's the general common law question of whether a new law should apply to activities and transactions that took place before it is enacted. And then secondly, there's the presumption that where a fundamental right is affected, there's a presumption against treating the law as affecting those rights. And so we rely on both of those. And we relied on those in the Court of Appeal. So we would say that the parties could not have intended, these parties could not have intended knowing of the existence of the Crown Land Ordinance in 2013 and knowing the effect of a rescission as opposed to a variation. They could not have intended for this to be a rescission when it was possible to do so by way of variation. And we say further that it could not have been intended that they would leave it up to the vagaries of having to negotiate new terms in respect of a transaction which they both which they both wanted and which they had already settled parameters. So we would say that.
But it might be said, might it not, that the correct interpretation of the ordinance is that it applies to where an original contract has been rescinded or where it's been varied to a certain degree.
Yes. Well, my Lord, what I would say about that is that it could not have been, and bearing in mind that this Crown Land Ordinance was of a general application. It was a new law which regulated the disposition of Crown land for the first time. And over many years, TCIG had been dealing in Crown land with various parties, so it could not have been intended that agreements that were made prior to 2012, that the parties intended that required some variation, that the rug would be pulled from under them merely because a variation occurred.
But we're back to our very difficult question of if you've got to amend in order to change various small items, perhaps that's one thing, but where is the line between that and something which looks like a different obligation, and how does that feed back in to how the CLO operates?
Well, my Lord, again, I go back to the question, and I obviously it's not before the board, but I think in one of the cases, it talks about it is the intention of the parties, and even a major variation, even a major change, and a major amendment is still a variation, if that is what the parties intended.
But if the variation is from $10 million down to $50,000, I think you accepted that would be so radical.
Yeah, that may be evidence.
Well, it's not evidence. If that's what the variation says,
Yes.
Does an intention that that should work by variation rather than rescission mean that the Act is thereby disapplied, the ordinance is thereby disapplied?
Well, my lord, yeah, no, my lord, I certainly agree. If it's a rescission, then the ordinance would apply. Yes, I certainly would agree with that.
Or is it your submission that a variation that radical must be treated as if it was a rescission?
No, my lord. You look at the agreement to see whether or not even a major variation is one which the parties intended.
But the parties can't, as it were, contract out of the ordinance.
No, my lord, I accept that, yes.
So doesn't there come a point at which, even if they were hoping or intending that they should be treated as a variation, it's still going to be called by the ordinance if it's substantial enough a change?
Well, I think the question is whether or not they intend to contract outside the ordinance, which they well, obviously which they can't do. They can't contract.
No.
Not no. Yeah, I accept that.
Dress up as a variation.
No,
or something which is such a change.
Right.
That on any view, the ordinance, as a matter of construing the ordinance, ought to apply to it.
Yes, it's a question of there is a question of substance over form.
Yes, absolutely.
Which I accept. But I would say that it is a in the context of this case, it is to go against what the parties clearly said in the 2013 agreement to suggest that they were somehow using form over substance. In my submission, that is a bold suggestion to make, that these parties would seek to circumvent the provisions of the CLO by dressing up as a variation what they knew to be a rescission.
But the premise upon which you're operating is that when one construes the ordinance, we can see a clear distinction between rescission, to which it does apply, and variation, to which you say it doesn't apply. But surely that's a matter of interpretation of the ordinance.
Well,
It's not clear to me where we're getting that from.
Well, my lord, as I said, you first have to decide whether or not in law there was a rescission or a variation. If there was a rescission,
if there was a rescission, end of story.
In law, yes, my lord.
We're in the grey area where, suppose there wasn't a rescission but a very fundamental variation.
Yes.
Why does the ordinance not apply to it? Bearing in mind that if you want to go from A to B, you can get there down a rescission route or you can get there down a variation route.
Yes.
But one assumes the ordinance was about whether the government should be able to go from A to B.
Yes. The ordinance has to be applied, as I said before, in terms of the substance.
But you're not taking us to the ordinance to show us which provisions we need to construe to carve out this distinction between variation and rescission.
Well, the ordinance does not, the Crown Land Ordinance itself does not address that question. But what I can take you to in terms of the ordinance is the question of and the meaning of the word disposition.
Yes. Right. Yes.
And you will see that in it's at page 638.
678.
638 is the ordinance. Sorry, 640 is the Crown Land Ordinance, and the relevant section is disposal at page 645. Which is disposal means a disposition of land following an allocation of it in accordance with section 108 of the ordinance of the Constitution. So, and then the word allocation, which is at 644, Because allocation in Crown land means a decision to dispose of the land, whether by way of sale or lease of the land, or the grant of the lease, easement or right over the land. So we would say that the decision to allocate this land to the developers was made in 2008.
Well, that's those meanings. Then the operative clause is where?
Well, the opposite clause is clause
It's 7.
Well, we've seen the purpose clause is in 5.
yes, and
Well, actually, it's in object of the ordinance in clause
Is it
4.
9, section 9,
section 9. Oh, yes, that is section.
on page 649?
Yes.
Right. So we would submit that.
It seems to be the case that the Act restrains the disposition even if there's been a pre-Act allocation. I mean, disposition simply defines what
Yes.
by reference to there having been a previous allocation.
Disposition. But if you, the Act sets out the circumstances under which a previous allocation could be questioned, and it's
Right.
let's see. There's a clause 8 which deals with recovery of Crown land, which
I see,
includes
yes, hold on. Yes, I see.
withdrawing clause 8.3. The action of the Crown land unit may take to recover Crown land includes, but is not limited, withdrawing letters of offer if the land falls in a protected area and should not have been offered by the government, determining leases that were not granted in accordance with correct procedures, and then cancellation of development agreements where the required development has not taken place. So we would submit that when you take all of this together, once an offer or a contract was made for the disposal of land, the Act does not apply to disentitled persons who have the benefit of those, except in specific circumstances.
But the word, I'm just looking at 8, clause 8 on page 648.
Yes.
Talks about in relation to any allocation of Crown land before or after that date, so before that date.
Yes.
And you've told us that allocation means a decision to dispose of the land.
Yes.
It appears to be saying where the decision to dispose even before 1st of April 2012, this clause applies.
Lord, I think the reason for the word allocation before is because there used to be an allocation register. So even for allocations which took place before the Act came into pass, you have to compile an allocation register. And so it was intended to capture so that it cannot be said that allocations made before 2012 ought not to be included in the register. But in my submission, it was not intended to enable the government to disentitle people who were properly allocated land before 2012.
So just if you'd be so kind to draw the threads together of your submissions in relation to this ordinance, this, could you do that for me, please, in a series of propositions?
Yes, my lord. My submission in relation to this ordinance is that it does not apply to contracts for the disposition of land which were made prior to 2012.
And this
that would include the 2008 agreement. Secondly, it does not preclude TCIG from varying an agreement made before 2012. And it is not required that such a variation is to be the subject of the procedure set out in the Crown Land Ordinance.
Yeah.
Those are my submissions on that.
Thank you very much indeed.
Yes, thank you, my lord.
Just about reached your time.
Yes. Thank you.
Thank you very much, Mr.
Thank you.
Missy. Shall we draw stumps here? Draw stumps now. All right. Ms. Mount.
My lady, the case as it's now presented boils down to this. In 2008, it is said by the appellants, the Turks and Caicos Islands government had an immediate obligation to transfer a 49-year lease, and that arose when the promise was given. The promise was given to undertake work, and the obligation was simply deferred until it is said $2 million was actually spent and reasonable proof of that given. And it's suggested that that obligation somehow remained in force even after Clause 5 of the Settlement Agreement of 2013 said that all obligations arising under that agreement were replaced by the 2013 agreement. And the fundamental change of consideration on both sides from 2013 in relation to the term of the agreement that related to the development lease. It is said that since the original source of some contractual obligation arose in 2008, it means that the fundamental change of obligation after 2013 doesn't matter. It doesn't matter that the appellant never did pay its $2 million. It said that TCIG still has an obligation to grant what is now a 999-year lease on substantially different consideration, and that obligation is not defeated by the terms of the Crown Lands Ordinance that was passed in April 2012. And so it seems to me that the issue as it's boiled down is whether the source of the alleged obligation to confer a lease, whether a 49-year lease or a 999-year lease, arose from Clause 4.14.4 of the 2008 agreement, or as the Court of Appeal held, and we submit, that the obligation was fundamentally changed by Clause 4.14.4 of the 2013 agreement. And that's the statement by the Court of Appeal that that clause was fundamentally changed is in paragraph 54 of the Court of Appeal's judgment, EB 328.
Sorry, page?
Page 328.
328.
Yes. Perhaps I ought to just take you to that because it is an important passage. paragraph 54, which criticising the judgment of the first instance judge, that she hadn't given consideration to the fact that under the 2008 agreement, PCIG acknowledged the previous payment, and that under clause 5 of the deed of settlement, each party had given the other a full release from incidents of non-compliance with obligations under the development agreement. And then they talk about the changes, the level of change to the agreement as a whole. And then the last 4 lines, it says, on the evidence and surrounding circumstances, it could not fairly be said it was a fundamental change that indicated rescission of the whole contract. But then this, it was a fundamental change in that clause. But the remainder of the 2008 agreement remained intact. And the issue, therefore, is whether, if that was a fundamental change in the whole nature of the clause which related to a lease or otherwise of these lands, whether that was caught by the Crown Lands Ordinance or not. But in deference to the shape of the argument as it's advanced in the appellant's case, and indeed the inquiries that my Lord Kitchen has made, will address whether any obligation had arisen under the 2008 agreement at all for TCIG to confer a lease. But if, as the appellant says, there was a promissory obligation to spend £2 million, then the waiver of that by the 2013 agreement was obviously a fundamental change. And if it was a fundamental change, we say the Crown Lands Ordinance applied. If, as we submit, there was no such obligation in the first place because the contingent condition of the payment of $2 million never arose, then we succeed because our construction of the 2008 development agreement is correct, and there's no earlier obligation upon which the appellants could rely in any event. Because the performance of that contingent condition the performance never occurred before the obligation was abolished by clause 5 of the settlement agreement.
But do you go so far as to say that if there'd been no 2013 agreement and things had continued and 2,000 million had been spent, that because the Crown Ordinance Act had come into force in the meantime, you were relieved from that obligation?
If the appellant had been under an obligation before 2012, when the Crown Lands Ordinance came into force, and had fulfilled that obligation before 2012, we would have been under an obligation to transfer a lease.
Well, I suppose it wasn't under an obligation, but on any view, didn't the clause 414, if it was that, wasn't that an undertaking by you made in 2008 that if and when $2 million of expenditure was incurred, you would transfer a lease?
Yes. If and when that was done, we would transfer a lease.
Yes, so given that had been entered into before the Crown Ordinance Act, the fact that fulfilment of it didn't take place till later, surely the Act wouldn't be construed as saying, well, nevertheless, you're released from that obligation that you entered into back in 2008 because of what happened, because of the Crown Ordinance Act being introduced 4 years after.
And that's why it matters whether we had an obligation which subsisted before the 2012 Act or not.
Well, you did, didn't you, on any view? It was obviously it wasn't going to be triggered unless and until the conditions were met. But it was a binding undertaken by your client that if and when they were met, the lease would be transferred, the lease would be entered into.
Lord, that's what the whole of the first limb of the argument is about.
You say you didn't undertake any binding, undertaking.
We say that we entered an undertaking, but the undertaking only arose when performance happened.
Well, it didn't. The undertaking was given in 2008.
Well,
you may not have had to do anything until performance happened. Obviously, you didn't. But you made the promise in 2008 that if and when the condition was met, the lease would be entered into.
That's why the issue of whether it was a contingent condition or a promissory condition matters. If they said, we promise We promise to spend $2 million, and when we've spent $2 million, you promise to transfer us a lease.
I don't see why it does matter. The fact is they promised various things. Whether that was one of them doesn't matter. There was a binding contract made. Or do you say there was no binding contract made?
Well, we say there was no contract made. It was up to, because it was because if you look at the development agreement as a whole, which was about $100 million worth of development, if they chose to undertake this aspect of the agreement and they chose to spend $2 million and prove it, then we would, if they did that, we would become under an obligation to grant a lease. But that obligation didn't arise until...
Okay, let me just give you a simple example. Suppose in June, I agree with the Crown that I will endeavour to raise enough money to buy a piece of Crown land for $10 million, and I'm given until December to find the money, but we enter into a solemn contract in June that if I come up with the money by December, the Crown will convey the land.
Yes.
And in November, the ordinance is passed.
Yes.
Does the ordinance strike down that agreement?
If you have promised...
That's not promised, just say,
well, if you have...
if it's an if contract, if I come up with the money by December, you will convey the land to me, and the ordinance comes in November. Do you say it strikes down that obligation?
Yes, I do.
Okay.
And that's why the distinction between the two situations and whether there has been a promise arises, because it may say if it rains in December, I will do something or other, which becomes ultra vires in November. It doesn't matter if it rains in December. You can't have the contract you can't have a contract that comes into force in December because in November that has become.
So you say you say the Act applies. It cuts in, if you like, notwithstanding a binding contract, if its performance falls due after the date the ordinance comes into force.
No, it's because the binding contract doesn't arise unless the contingency, the finding of the money happens.
Okay.
And that's why that slightly arcane distinction between the contingent condition and the promissory condition matters. But as this is boiled down, and the question which is appears to be of greater interest to the board, and is in my submission, in any event, a complete answer to the appellant's case, is that the slightly artificial distinction between total rescission or variation isn't actually the answer. The question is whether the material obligation has been so varied as to be fundamentally changed after the date of the CLO. And if this obligation, never mind the contract as a whole, which is about $100 million worth of development, various bits of which remained as were, and the Court of Appeal talked about how much this has changed.
Just so we got it in mind over the short adjournment, what do you say the legal test is? Is it fundamental obligation, radical change? What's the legal test which governs the question whether this Act applies where there is something which is expressed as a variation but is in quite fundamental terms?
It's whether the bargain between the parties has changed in a fundamental sense. And my Lord, just...
It's essentially fundamentality.
I'd say my submission would be fundamentality, but may I just draw particular attention, my Lords, to the concept in clause 2 of the Crown Lands Ordinance, which Mr. Missick took you to.
Yes.
Just give us the electronic page reference.
EB 644.
644, yeah.
Yes. An allocation in relation to Crown land means a decision to dispose of the land, whether by sale, lease or otherwise. So the question is whether the decision to dispose of the land by this lease occurred before the Crown Lands Ordinance was in force or another, or after it. And the decision to dispose of a lease for $2 million for 49 years and a decision to dispose of a lease on mere notification that you propose to start work for 999 years is so fundamentally different that I say that the 2013 decision is after the Crown Lands Ordinance, if you interpret this.
It's not the same decision.
It's not the same decision, so it's a fundamentally different decision about land allocation.
No, it's not enough that there was a decision. It must be the decision.
The decision, yes, yes. It's the decision. Well, it's a decision, but there are two decisions here. There's the 2008 decision and the 2013 decision, and it isn't like the Sarah Lee case, which was we will undertake a deal for $61 million, well, we'll undertake fundamentally the same deal for £1 million more for slight variations. You can see why, for capital gains tax purposes, they say you're stuck with the date of the decision as to disposal, fundamental decision. But here we've got two decisions, and one is so fundamentally different from the other that I say that the later decision, which postdates the CLO, is caught by its terms and caught by the terms of clause or section 34, which is the relevant one on allocation of commercial land. That's page 663.
The Court of Appeal did make a declaration about this, didn't they, which you're not challenging on this appeal, about the effect of the...
about variation and rescission.
Well, about it not being of retrospective effect.
No, we don't. No, I don't challenge that. That's obviously right. But it's not of retrospective effect. But the question is what postdates it and what predates it. And I do rely on what the Court of Appeal said about this clause, about this decision to allocate land having fundamentally changed.
Yeah.
Just before we leave what you've classed as the other issue in the case, which may not be, I think as you're now suggesting, so significant, whichever way one goes on it, am I right in understanding that the way it was put by your opponent was that you were advocating a unilateral contract analysis, whereas he was advocating a bilateral contract analysis? Is that how you see it? Is that effectively the same as your promissory or contingent condition point?
Yes, my Lord, I must confess that this point, and I wasn't in the Court of Appeal, Mr. Missick was, or the Supreme Court of TCI, but the judgment, the first instance judgment, suggests that the promissory nature of the clause was conceded at first instance. Mrs. Justice Ramsey Hale says at 301 that it was common ground that that less than $700,000 had been spent by the developers by the time of the 2013 development agreement, such that prior to execution of the 2013 development agreement, the developers had no right to demand the parcels be vacated and the lease executed in their favour. So that's why we've gone down this route about whether any obligation arose before the decision, because the, as I understand it from the judgment, the argument in the Supreme Court, the first instance court, was whether the 2013 development agreement completely replaced the 2008 agreement. And it's now become more nuanced, which is whether the 2013 clause effectively, fundamentally replaces the 2008 clause.
Well, I think we'll have to adjourn until 2 o'clock now, I think.